Good afternoon, ladies and gentlemen. Welcome to the IP Roundtable organized by the Hong Kong Trade Development Council and the Hong Kong Reprographic Rights Licensing Society, and sponsored by Creative Industry, the Cultural and Creative Industries Development Agency, on the occasion of the HKTDC Hong Kong Book Fair 2026. 各位来宾，欢迎大家出席由香港贸易发展局及香港书刊版权授权协会举办、文创产业发展处资助的 IP 圆桌会议。The session will be conducted in English. Simultaneous interpretation service will be provided. You may find the headsets at the reception counter outside. For English, please choose channel 4. For 普通话, please choose channel 5. Thank you. 请注意，本次会议将以英语进行，我们安排了即时传译服务，耳机可以在房外的登记处领取。第4频道为英语，第5频道为普通话。To kick off the session this afternoon, may I now invite Ms. Smiley Lam, Associate Executive Director, Hong Kong Trade Development Council, to come on stage to deliver welcome remarks. Ms. Lam, please.
The Honourable Kenny Fogg, Ponch, Christine, and Sharon, distinguished guests, ladies and gentlemen, good afternoon. A very warm welcome to the IP Roundtable of Hong Kong Book Fair 2026. As one of Asia's leading publishing and cultural events, the Hong Kong Book Fair has long been more than a platform for promoting reading and cultural exchange. Over the years, it has also become an annual gathering for book lovers, publishers, and industry professionals from around the world. Building on the success of the past 2 years, we are delighted to once again collaborate with the Hong Kong Reprographic Rights Licensing Society in organizing this IP Roundtable, with an aim to support IP trading and the sustainable development of the publishing industry. This year's theme, Copyright in Transition, Reshaping Rights, Challenges, and Opportunities in the Age of AI, is especially timely. Artificial intelligence is rapidly transforming every industry, including the publishing and creative sectors, from content creation and translation to licensing, distribution, and copyright management. At the same time, governments, policymakers, and industry stakeholders worldwide are also exploring new approaches to address evolving issues surrounding authorship, licensing, and content protection. We are honored to have a distinguished panel of experts here with us today who will examine how these developments are influencing copyright owners, reshaping licensing models, and also creating new opportunities for innovation and cross-border collaboration. The discussion will also explore emerging trends in the global IP market and provide practical insights to help industry players navigate an increasingly digital and interconnected landscape. Through initiatives such as this morning's International Publishing Forum and today's IP Roundtable, the Hong Kong Book Fair brings together industry leaders and professionals to exchange ideas, build partnerships, and explore opportunities in the global publishing market. The IP Roundtable underscores the HKTDC's commitment to supporting the publishing and creative industries, while reinforcing Hong Kong's position as a regional center for IP trading and also a super connector between East and West. This year is also particularly meaningful for the HKTDC as we celebrate our 60th anniversary. Over the past 6 decades, we have evolved alongside Hong Kong and the global business landscape, helping industries to innovate and also connect with the global opportunities. And we will continue our efforts to strengthen Hong Kong's position as an international cultural and business hub. In closing, I would like to express my sincere gratitude to our distinguished speakers here and also our partner, Hong Kong RRLS, for their continued support in making this meaningful event possible. And I would also like to thank the Cultural and Creative Industry Development Agency of the Hong Kong SAR government for their continued support of this IP Roundtable over the years. So I wish you all an insightful and fruitful discussion afterwards, and also for our overseas guests, a very pleasant and enjoyable stay here in Hong Kong. Thank you very much.
Thank you, Ms. Lam. Please be seated. Next, may I invite the Honourable Kenneth Fok Kai Gong, BBSJP, Member of the Legislative Council of the Hong Kong Special Administrative Region, to come on stage to deliver his opening remarks. The Honourable Fok Kai Gong, BBSJP, please.
Good afternoon, friends from Hong Kong and of course all over the world. Smiley representing the government, Sarah, Rashid, Christine Ponch, Sharon of Guamaj, meeting new friends today and also seeing old friends today. So really it's a great pleasure to be here to share the stage with you for a short few minutes during this, if I'm not mistaken, third edition of IP Roundtable 2026. Of course, this event happens in conjunction with the book fair. And for our friends from overseas, just an additional note, our book fair is one of the most exciting times in Hong Kong. We welcome over at least 1 million visitors over a short span of few days with book fans, publishing fans, and all over the world coming to Hong Kong as well. So it's definitely one of the great fairs organized by the TDC. And loved by the locals. So thank you. It's an exciting occasion to be here. And it's really delighted to see so many delegates from UK, Norway, Malaysia, UAE, and of course, IFRRO. Your participation here really gives us a boost of confidence, not just for Hong Kong, but for our industry and for our collaboration in making the international intellectual property market and landscape better. And it is really our hope to push beyond borders, to push beyond what we're doing now, to achieve a higher level. And just again, for the benefits of our friends from overseas, Hong Kong is really determined to invest in our culture scene and specifically also development of international property and also the trading of the international property. China, on the country level, we just passed the 15th five-year plan. So work on a 5-year planning cycle. And for the next 5 years, there's much stress in the need for more human-to-human exchange, ideas-to-ideas exchange, culture-to-culture exchange. And as a Hong Kong, as a special administrative region, as one of the most open city trading hubs, I think we have a responsibility to serve and also to help our country's development of such an initiative, being the bridge between, if you say East or West, or Hong Kong and other cultures. And this is really very close to our hearts, and this is what we've been doing. And I think this is also at the core concept of the book fair as well. So it's not a simple fair where books are traded, they are displayed and sold. But this is the occasion that we are actually treasure the most, having the opportunity to talk on very important issues such as IP trading hub. And to be more specific, Hong Kong has been tasked to develop 8 centers. I won't bore everyone with the nitty-gritties, but of course, one of them is the IP Hub Training Center. So this is very adept that we're having this conversation right now. Artificial intelligence, yes, it's going to come up in every conversation, but it's something, of course, it needs to be discussed in a positive way. Of course, it's transforming the way we create, how contents are created, but more importantly, how we protect created content and how these contents are being shared. I always hold the view that AI, presents tremendous opportunities for innovation, but of course it presents great challenges as well. Questions about copyright, licensing, authorship, and long-term sustainability of the creative industry. And I think honestly, it's been moving so fast. We are getting used to the landscape, but I understand that the industry also worried at the same point. And this is not just a Hong Kong unique problem, it's facing jurisdictions all around the world. So as a legislator representing publishing and the creative industry, it's my role to liaise with all of you, also convey to the government, not just to see what the latest trends are, but really try to be a trailblazer in this field, because we have to develop, I hope, to be one of Asia's leading IP trading hubs. So these are all the questions that we need to be addressing at occasions like this, and allow stakeholders to benefit from Hong Kong's unique positioning and our expertise. So again, it's so happy to see a full room full of experts and people interested in this topic, and through constructive dialogues, we hope to use your valuable insights to push this agenda further and identify new opportunities for collaboration, innovation, and sustainable growth in this new age of creativity and AI. Finally, I would like to really express my sincere gratitude and appreciation to CEDA, Hong Kong Trade Development Council, TDC, and the Hong Kong Reprographic Rights Licensing Society for organizing this meaningful event for the 3rd edition. One edition better than the previous one. So a lot more room to grow and work hard together. I'm sure we'll achieve great things. Thank you very much, and I'm sure all of us will benefit from a fruitful discussion. Thank you so much. Thank you.
Thank you, the Honourable for Kai Kong.
But
Please-
unfortunately, I have to go back quickly because we're in the middle of legislating some other legislations. So I might not be able to join you for the full discussion. Thank you very much. Thank you.
Please remain on stage and proceed to the center. Here comes to our group photo session. May I first invite Ms. Smiley Lam, Ms. Christine Chia, Head of Architecture, Printing and Publishing and Promotion, Culture and Creative Industries Development Agency of the Government of the Hong Kong Special Administrative Region, and Mr. Ponch Poon, Chairman, Hong Kong Reprographic Rights Licensing Society, to join us on stage. Finally, may I invite all our distinguished speakers to come on stage for a group photo.
Check outside a bit. Okay, this way. Okay, this way, center, please. This way, 1, 2, 1 more, 1, 2. Okay, one more. Okay, this way.
Thank you all. Please be seated. As a token of appreciation, we will now have a souvenir presentation for our guests. May I first invite Mr. Poon, Chairman of the Hong Kong Reprographic Rights Licensing Society, to come on stage to present the souvenirs. Next, may I invite Mr. James Bennett, Head of Rights Holder Relations, the Copyright Licensing Agency, United Kingdom, to come on stage to receive the souvenir.
Okay, one more this way. One more. Okay, thank you.
Ms. Hige Munch Gunderson, CEO, Copenor, Norway, to come on stage.
Okay, one more here. This way, smile. 1, 2. Okay, thank you.
Mr. Ahmed Hussein, CEO, Malaysia Reprographic Rights Center, Malaysia. Thank you, Mr. Hussein and Mr. Poon. Please proceed off stage. May I now invite Ms. Smiley Lam, Associate Executive Director, Hong Kong Trade Development Council, to come on stage to present souvenirs to our honorable partners and speakers. Ms. Lam, please. May I now invite the following speakers to come to receive the souvenirs. They are Dr. Sharon Wong, Executive Director, Hong Kong Reprographic Rights Licensing Society. Ms. Teresa Look, Partner, Intellectual Property, Deacons, Hong Kong. Ms. Majd Hassan Al-Shihi, Director, the Emirates Reprographic Rights Management Association, UAE.
One more this way. 1, 2. One more here this way. 1, 2. Okay, thank you.
Ms. Sarah Tran, Director of Regional Policy and Public Affairs, International Federation of Reproduction Rights Organizations, Belgium.
Okay, one more here. 1, 2. One more this way. 1, 2. Okay, thank you.
Thank you, Ms. Lam and Ms. Tran. Please proceed off stage. Artificial intelligence is transforming industries across the globe at an unprecedented pace, creating both new opportunities and new challenges for intellectual property, publishing, and the wider creative sector. To explore these important developments, we will now hear from our distinguished speakers who will share their insights on the evolving IP landscape in different regions, the impact of emergent regulations and licensing models, and the opportunities for innovation and cross-border collaboration in the age of AI. Their presentations will offer valuable perspectives on how stakeholders can navigate a rapidly changing environment while harnessing new opportunities for growth and creativity. 人工智能正以前所未有的速度改变全球各地的产业发展，为知识产权、出版业及整个创意产业带来崭新的机遇和挑战。为进一步探讨这些重要的议题，我们接下来将邀请多位讲者分享他们对不同地区知识产权发展趋势的观察以及他们的意见。Without further ado, the panel discussion will now begin. Please join me to welcome our speakers on stage. We are very honored to have Dr. Sharon Wong to moderate the session. Over to you, Dr. Wong.
So may I also invite all our panelists on the stage, please? Good afternoon, distinguished guests, speakers, colleagues, and friends. It's my great pleasure to welcome you all to the IP Roundtable 2026. At today's roundtable, we will explore how different ROOs, we are all from the reprographic rights organizations in different countries and regions, are responding proactively in the AI era. Some markets have already moved towards the implementation with AI-related licensing solutions in place. like those in the UK and Norway. Others are the preparation and the advocacy stage, as in the UAE, Malaysia, and Hong Kong, working to hold awareness, build awareness mandates, legal recognition, and policy support. And today, we are honored to have with us an excellent panel of speakers from IFRO, Norway, the UK, UAE, Malaysia, and Hong Kong. Each of the panelists will share their perspectives, followed by moderated discussion and questions from the audience. Our first speaker is Ms. Sarah Tran. Sarah from IFRO. And Sarah, may I invite you to begin by sharing IFRO's international perspective on how ROs are moving from copyright advocacy towards practical AI-related licensing solutions and market development. So, Sarah, the floor is yours.
Thank you, Sharon. Firstly, can I just say how delighted I am to be here in Hong Kong. It's a real pleasure to be here, and very, very honoured to be able to contribute to these very important discussions. My many thanks to CEDA and HKTDC, as well as HKRLS for having me here with you today. So just a little bit about IFRO. I've got a few devices going here, so hopefully it'll be okay. But just a little bit about IFRO to begin with. I'm sure many of you are not familiar with our organisation, but we are headquartered in Brussels, Belgium, and we are the global industry body for RROs around the world in the text and image sector. So we have 160 members across 90 countries, and through these members, we represent millions of creators. That includes writers, authors, journalists, publishers, and visual artists right across the spectrum. Millions of creators worldwide. And in our work, we're very focused on, first and foremost, advocating for copyright and for licensing solutions, and as well as supporting good practice amongst our CMO or RO members and to support collective management frameworks around the globe. Just a little bit about us to begin with. So while we're headquartered in Europe, we are very much a global organisation. So I, for instance, I'm based here in the Asia-Pacific region. You can probably hear from my accent, I'm Australian. Over the past year alone, we've participated in well over 30 international events, including at WIPO, the World Intellectual Property Organization, and UNESCO forums. And this is largely focused on our work with AI. Additionally, we've delivered over, I think probably 45 at this stage, in-person and online events. We've made over 25 detailed policy submissions to government consultations around the world as well. So we're very committed to advocating for copyright and for sound copyright frameworks around the world. Just moving to the next slide now. Just wanted to highlight that in our work, we have deep collaborations with many intergovernmental as well as regional partners. We work very closely with WIPO, not only at the SCCR level, but also on development activities. So we've worked with WIPO on development activities across Africa, also the Asia Pacific, and also the Latin American countries, as well as actually quite recently Eastern European countries too. So we work quite closely with WIPO on not just policy discussions, but also on technical solutions, such as WIPO Connect, which is a rights management system for RROs, as well as things like WIPO for Creators, which is a rights management learning centre really for creators around the globe. And we do this in pursuit of our goal of upholding copyright as the underpinning foundation for robust and sustainable creative economies. And it was so great to hear the Honourable Kenneth Fock mentioning earlier how the government here in Hong Kong is very focused on developing and sustaining your creative industries. So while IFRO and our members, of course, we have a very significant role to play in terms of advocacy, but that is not at all our only role. I think probably first and foremost, our role is to offer practical, scalable solutions for market needs. So in the context of AI, we've moved very fast in our sector from the very, very bewildering early days of ChatGPT launching onto the market, or exploding onto the market, I should say. And increasingly, we are seeing RROs moving towards practical AI licensing solutions. And I'm really pleased to see, I remember participating in the first roundtable 3 years ago, and I was talking about how licensing exists and we can move very quickly. And at the time, it was more like a crossed fingers situation, but I'm very happy to see that the shift is actually real and it's accelerating. So while governments around the world are continuing to grapple with legislation, which takes a lot of time, and they're continuing to grapple with the applicability of various exceptions in the law, ROs have evolved very quickly, very rapidly, towards building fit-for-purpose licensing solutions. Across all the regions that we work in, which is the world, we are seeing an increasing number of licensing solutions enter the market. These are fair and sustainable solutions, fair and sustainable licensing models that facilitate the remunerated use of copyright works in AI systems. So I think, as we all know here, the cornerstone of any creative industry, any sustainable creative industry, is the international copyright framework. I would argue that the current framework across the globe allows copyright owners to control how their works are used, effectively monetize their works, and also provide the economic incentive for them to keep creating new works. Licensing has long played a very crucial role in this balanced copyright framework, and in recent years we've seen an increasing number of agreements between AI companies and individual creative industry stakeholders. Those agreements are very commercially sensitive, so we don't hear about the detail, but we know that they're happening, and that confirms the ongoing relevance of direct licensing. And in parallel, many ROs in the IFRA community, mandated, of course, by their rights holders and users, have begun to develop collective licensing options tailored specifically to AI use cases. And these collective licenses represent a really significant shift in how licensed content can be leveraged in AI systems. In this slide here, you can see just a couple of examples that I pulled out. So in the United States, CCC, our member there, has incorporated AI reuse rights in its annual copyright license for the business sector. And this covers internal use of copyrighted content in AI systems. And CCC also, I think in the last 18 months, has launched an AI systems training license to permit AI developers to use lawfully acquired works for model training, and also for the generation of externally accessible outputs. Now, this is quite a big deal. When you hear tech companies talking in news media reports, you'll hear them often saying, you know, there are no solutions out there, it's too hard. I think the CCC example, they moved very quickly, like ChatGPT exploded onto the market late 2022. I think they launched their license end of 2023. In Japan, JAC, our member, has expanded its digital copyright license to cover AI use cases, and this was developed in partnership with Rights Direct Japan. This provides companies with lawful access to global and local repertoire for tasks such as summarization, extraction, and internal analysis. Another example is over in Germany. VG has introduced an AI licensing framework which allows internal AI training and output generation within defined limits. And a little bit closer to home in this region, in Australia, the Copyright Agency has extended its annual business license to cover staff prompting of news media content in Gen AI tools, and they are currently exploring other extensions to be launched later this year. And interestingly, the statutory license in Australia for education, so schools as well as universities and the government sector, already include AI activities. So it's a very flexible system that they have there. And we're going to hear shortly from my excellent colleagues here, Hagar and James, about the very innovative solutions they've developed in the UK and Norway. And there's also a raft of other licenses that we're looking at being launched into the market later this year, including from our colleagues in Belgium, colleagues in Denmark, and I'm sure several other countries to come. So I wanted to take a moment here to talk a little bit about AI governance and to explore the respective roles of government organisations as well as ROs as it relates to AI. National governments and especially intergovernmental bodies such as WIPO, I would say, have a really essential role to play in setting and clarifying the legal conditions or the legal foundations for AI development as it intersects with copyright. This includes doing things like confirming that AI training and use of protective works requires authorization. This is a fundamental principle of copyright that has existed since copyright has existed. It requires consent and authorization. Governments also have an important role to play in terms of ensuring transparency obligations on AI developers, and also ideally in avoiding unilateral exceptions that fragment our global market. So we at IFRO have taken on quite a bit of work in this area. We've engaged directly with governments. Most recently, I've been working with governments in South Korea, Vietnam, and India. But my colleagues have also been working with governments all over the globe. And in our work, we try to highlight that licensing is a core component of a balanced copyright framework that supports both innovation and investment. We try to emphasise that legal frameworks should support fair licensing markets, should avoid unfair arbitrage, and uphold core copyright values, including authorisation, transparency, fairness, accountability, and equitable remuneration. In parallel, there is a huge opportunity for us in the IFRO community, us RROs, to carry out, in close consultation with our rights holder members, the operational work that governments simply, probably aren't inclined to do and also probably can't do. This includes doing things like aggregating repertoire, setting fees, running the collective licensing infrastructure. It's quite a complex infrastructure that comes with collective licensing. You've got to do the surveys, you've got to run the distributions, you've got to keep hold of your rights holders. So it's quite complex work. And in short, RROs can provide AI companies and developers with a lawful and scalable point of access. So I think most people in this room would know that licensing, both direct and collective, in licensing and transparency are the essential pillars for lawful access, for ensuring lawful access to protected works and building trust in the AI systems. I'm sure you all heard that term as it relates to AI, rubbish in, rubbish out. So we're looking at really good quality content to feed the AI machine so what the AI machine spits out is actually reliable and trustworthy. I would, however, say and really try and emphasise for this forum that it's a shared responsibility. It should not fall on the rights holder alone or the CMO or the RRO alone to try and negotiate with rights holders, with AI companies. I think government policy really needs to make a space for licensing markets to function, and RROs really need to deliver on that space. So once that space has been created, it's really up to us to deliver solutions that actually work in the market. And to help RROs deliver, I just wanted to go through some of the work that IFRO does for our members. So we offer capacity building assistance, not just on a day-to-day operational level, but also in terms of AI licensing capacity. So we have quite a few prongs to this. It's a very multi-pronged approach. So first and foremost, we have policy tools and resources. So we have an AI position paper that sets out core principles that highlights that authors, creators, and rights holders need appropriate protections, that policy changes must be based on strong evidence and study, and that policies must be balanced, and education and transparency are critical to successful policies. We also offer practical guidance, so that in April this year, we offered a AI governance tool, which gives members a clear practical vision of AI governance based on copyright principles. And it covers the full life cycle of AI, from training models to bringing training models to market, text and data mining regimes, and also the growing role of licensing and collective management. At IFRO, we also have commissioned a number of pieces of research to develop an evidence base to give our members the data to design proper licenses and to make the case to governments. There's also a big part of our work that's focused on peer learning. So our regional committee, which is actually our vice chair is sitting right here beside me, Dr. Wong. The Asia Pacific Committee is explicitly used to help advanced RROs connect with less advanced RROs and walk them through what's working and what's not. And we have similar committees across different regions. As I mentioned earlier, we also offer direct advocacy support, engaging directly with governments on behalf and alongside our members. And then there's also quite a big element of multilateral engagement. So we participate in intergovernmental fora such as WIPO's Artificial Intelligence Infrastructure Interchange, AIII. We participated in the launch earlier this year, and this gives members visibility into emerging international infrastructure for licensing and attribution, rather than expecting RROs to sort of reinvent the wheel themselves every time. So this is just sort of reiterating that, but I just want to highlight that we also have an AI advocacy toolkit. This is our primary technical reference for members on copyright liability arising from AI training. I talked a little bit about the AI governance guide already, and we also continue to facilitate structured dialogue through targeted webinars, member calls, and regular monthly AI updates. And we also engage regularly with all the international organisations, including our partner organisations in different creative sectors like CESAC and IFPI. And really, we're focused on advocating for our members across an extensive range of AI-related forum. Just coming to the end of my presentation now, I also wanted to highlight that we have a very practical tool through the IFRO community as well. We established recently the AI Licensing Task Force, and this task force was established in October last year following member demand for practical AI licensing guidance. And this task force is chaired by the lovely James Bennett. And the aim of this task force is really to improve shared understanding and support for RROs in developing their AI licensing approaches. The focus is really practical and technical. It's not a policy forum, but it's really focused on sharing day-to-day learnings. And the approach is, we're all from different countries around the world. We have regular calls online. We share drafting of different documents. And so far, we have developed 3 resources. First and foremost is the AI Licensing State of Play, and this is available from the IFRO website, and it's a very useful, I would say it's useful, but I do think it is useful. It's a 4-page summary of all the licensing solutions that are out there at the moment. And we've also just about to launch the best practice guidelines on rights acquisition for our RRO members and also establishing licensing parameters. So these resources are really, they're all available from the IFRO website, and they really provide the foundation for IFRO's continued engagement on AI issues. And we continue to try and support our members and actively contribute to the promotion of responsible and transparent approaches to AI. A big part of our motivation in developing these resources is really in recognition, and I think Kenneth Fock mentioned it earlier, it's recognition that the potential impact of AI on copyright industries is global. While the solutions need to be tailored, of course, to local conditions, local jurisdictions, we truly believe at IFRO that common principles, model terms, and best practice guidance, they're going to be essential if we're going to achieve effective regulation and robust governance of AI. And that this is not to try and contain AI, but it's trying to make sure that AI reaches its full potential in service of humanity. It's really important to talk about these guiding principles because when we're talking about AI, we're really talking about a handful of developers that are operating on a truly global scale. They are very well resourced, they're impatient, and as we've seen from the many, like hundreds of court cases around the world, they're not particularly interested so far in playing by the rules. So AI developers are operating globally, and if we don't figure out a way of getting some kind of international harmonization, we're going to end up with a system where the AI companies will route around fragmented and inconsistent licensing terms. So it's our belief that a shared suite of principles, a definition, baseline transparency and remuneration requirements is really, really essential. And of course, in saying that, it's essential to note that every jurisdiction is different. Markets differ hugely in terms of maturity and local conditions. So our guidance is intentionally principles-based and adaptable and not focused at all on a single model. So I guess in closing, I would just reiterate that the cornerstone of creative industries, massive contributions to the creative economies, to the global economy, is the copyright framework that exists. The system, I would say, has evolved many, many times through many different types of technology over the years. And on this new AI frontier, I fully expect that it can evolve again. And it's our hope that IFRA's AI resources will offer some basis of a common framework. That's the end of my intervention. So thank you so much for your attention. And I look forward to our discussions.
Thank you. Thank you, Sarah, for setting the international context. We now turn to Norway, where we will hear about a concrete example of government and RRO working together through collective licensing. Let me introduce our next speaker, Ms. Hagen, the CEO of Copynor in Norway. Copynor's experience is particularly significant. Its licensing agreement with the Norwegian Ministry of Culture provided important examples of how government and an RRO can work together to provide a lawful access support to the educational needs and safeguard the interests of authors and rights holders. Hagen, please. Thank you.
Thank you. Good afternoon, and thank you, Sharon, for the introduction. And I would also like to express a big thank you to our distinguished host for the invitation. It's a great honor to be here in a Hong Kong Book Fair. When people hear that Norwegian publishers and authors have agreed to license protected work for AI, the most common question I get is, how on earth did you get them to say yes? The answer to this is my main topic today. There are many good reasons to be skeptical about generative AI, especially about the way large tech companies have used protected content without permission. But the reason we got here is not that the concerns disappeared, it was that they were taken seriously and negotiated into the agreements. Copynor now works with AI-related licensing in two main areas. The first is training of language models. We have negotiated agreements with the National Library of Norway, one for newspaper content and one for books and similar publication. The second area is internal use of protected content in AI tools, when content is used as prompts or context in school, public administration, and workplaces. Today I'm asked to mainly focus on the training agreement, and I'll only briefly mention the other framework. In Norway, the language argument has been particularly strong. Norwegian is a small language, and we also have two separate written Norwegian languages, as well as Sami language. So language models are not only technology, they're also linked to policy, culture, and national preparedness. In the last couple of years, language models have increasingly been linked to sovereignty. The need for national AI infrastructure, greater transparency, and alternatives to big tech. For Copynor, it has also been important to secure lawful use of protected content and to ensure that right holders are remunerated. Before I describe the agreements, I want to underline one point. The hesitation from the right holders was legitimate. It was not only resistance to new technology, it was concern about control, value, future markets, and the integrity of creative works. Publishers were particularly concerned about market disruptions. Would this undermine existing and future business models? Would it enable competing services built on their own content? Author organizations shared those concerns, but also placed particular emphasis on the work itself, possible reproduction, imitation, and outputs in the style of the author. One question guided the entire process. Under what conditions could right holders allow training without weakening their own future position? The process started with an assignment from the Ministry of Culture to the National Library of Norway. The ministry asked two basic questions. Does protected material actually add value when training language models? And if so, what could a compensation model look like? This led to a research project in 2024. The findings were clear. Protected content does add value. Newspapers, non-fiction, and academic literature were especially important for improving the models. The evidence mattered. It made the political case stronger, and it also made it clear that right holders should be paid. We then had two negotiation tracks. For historical reasons, the Norwegian Media Business Association led the negotiations on the press material, while Copinor, the Norwegian RRO, handled the negotiations on books. But in both cases, collective licensing was essential. The number of works and right holders is simply too large for individual clearance at this scale. The newspaper agreement was the first to be concluded. A total of 4.2 million euros was allocated in the 2026 national budget, and the agreement was signed in December 25, with Copinor as the contracting party. The agreement covers press publication published in Norway, but only up to 1 year from the date of publication. This limit was to protect the commercial value of recent journalism and current news service. The book negotiations were more difficult. The parties reached agreement in March this year after 2.5 years of dialogue. The agreement covers books and similar publications published in Norway. The agreement has not yet been finally signed because funding in the 27 national budget is still a pending condition. But last week, the Ministry of Culture confirmed that the parties may sign a letter of intent. That means we expect to be able to translate and publish the agreement already in August, so that it will be available on the Copinor website, even before the funding is finalized. Authors and publisher organizations were involved throughout the negotiations through a smaller group. We discussed the risk before we discussed the solution, and we tried to translate each concern into a contractual mechanism. Market disruption into exclusion and limitations, author integrity into license terms and output restrictions. Corpus security into access restrictions, and future value into terminal agreement with annual remuneration. That was perhaps the most important part of the process, making the risks concrete enough to negotiate. The permission is limited in several important ways. Recent publisher literature is excluded. For books in Norwegian, the rolling limit is 10 years. Schoolbook and academic textbooks published after 1980 are always excluded. Textbook being especially vulnerable, of course. Book editions that are still registered as being for sale are also excluded, and translated work are also left out, with some specific exceptions for translation between the Norwegian written languages and the Sami language. These exclusions are answer to the publisher's core concern: the agreement must not undermine active markets. Another important boundary is the distinction between general base models and specialized models. In simple terms, we wanted to draw a line between building general language infrastructure and building a commercial product for a specific market. The agreement covers the first, but not the second. If someone wants to train a specialized or domain-specific model based on selected content, that's outside the permission. It would require new negotiations, either with copynor or directly with right holders. This was essential to safeguard future business opportunities. The train model may be freely shared, but they do come with some obligations. The most important licensing terms are these. You must not intentionally recreate material from training data, and they may not use the models to develop services whose main purpose is to create books or news services. And you may not generate output that emulates the style of an author whose work are protected by copyright. The train models may be shared under license terms, but the training corpus may not be shared with third parties. It's important to stress that the work themselves do not become a shared resource. Both agreement, books and newspapers are limited. They are terminable. They include opt-out rights, of course, and they are followed by regular monitoring and contact meetings. That matters because AI technology changes, as we know, very quickly, and we needed a framework that allows the parties to learn as we go and to adjust the agreement if necessary. This slide summarizes the logic of the agreement. The concerns about the market disruption led to exclusion of active market, recent books, textbook, and competing publishing services. The concern about loss of future value led to distinction between base models and specialized models, annual remuneration, and a terminable agreement. The concern about author integrity led to restrictions and recreations in the style of outputs. And the concern about corpus control led to the rule that the corpus cannot be shared. And I think this was what made the right holders move and say, okay, go ahead, because the boundaries were so concrete. Very briefly, I also want to mention our second AI licensing area, internal use of protected content in AI tools. We have reached a new framework for schools and municipal administrations after very difficult negotiations that in fact ended in state mediation this winter. Here, protected content may be used as prompts or context in generative AI tools, but only within the ordinary licensing terms, which includes, in Norway, the 15% rule. Only 15% of the work can be copied. Works may be adapted, may not be adapted, except for translation or minor linguistic updates. The content may not be used for further training or development of AI tools. An output based on identifiable protected sources may only be shared internally. We are now implementing the same framework in workplace licensing or business licensing, and for higher education, the negotiations start in September. So we are keeping our fingers crossed that it will turn out a good agreement there as well. To conclude, We're often confronted with the statement that AI provoke a choice between innovation and rights. The real challenge, I think, is, of course, to build innovation on rights with permission, payments, and control. Thank you.
Thank you. Thank you, Helge. I believe this will be an excellent reference case for us in Hong Kong as well. And we will now move on to the UK, where the debate on AI, copyright, and TDM exceptions has been particularly active, and where CLA has developed a market-led AI-related licensing solutions. So our next speaker is James, Head of Rights Holder Relations at CLA, Copyright Licensing Agency in the UK. So James, may I invite you to share your experience? So over to you, James. Thanks.
Hi, everybody. Thanks very much to our hosts. Thanks for inviting me back again this year to Hong Kong to speak at the book fair. And yeah, this time I'm going to talk to you about our AI licensing initiatives, where we've got to and how we got there. So it's a shame the font's not worked well on the slides, so hopefully it will be at least legible, if not very attractive. Sorry about that. So first, a little bit about the Copyright Licensing Agency. We are an RRO. We help our customers to legally access, copy and share published content, books, magazines and journals. We make sure that copyright owners are paid for the use of their works. We are owned by authors, publishers and visual creators, and we're a non-profit organisation, so all the money that isn't used to run ourselves goes back to rights holders. And we have been around since 1983, and we've distributed over £1.5 billion in collective licensing revenues since then. So I was asked to, first of all, speak a little bit about the situation in the UK with regard to copyright policy and AI. So since the successive UK governments have been looking at changing copyright law to basically make it easier for AI firms to train on UK published content for quite a long time now. The UK government the current government ran a consultation starting in December 2024, where they gave a preferred option of an exception subject to opt-out. There was a great deal of response from the creative industries and rights holders to that consultation, and it took them nearly a year to give a formal response to the inputs and to kind of make a decision on what they were going to do. And the decision was really that the broad AI exception with a rights reservation or opt-out is no longer the UK government's preferred option, which is great. They have said that they're not proposing any immediate reform to copyright. Instead, they're building evidence, they're monitoring the market, and they're looking at legal and international developments, which is why it's really good to see that licensing of AI and collective licensing of AI is developing in so many different countries. The government did say that they consider that licensing is important, and that they were not going to make any current market intervention. But there are obviously some key unresolved issues in relation to AI and licensing. First of all, transparency. It's very hard to license if it's not clear what's been used to train. Even if you are pretty sure that an AI firm trained on your work, it's very, very hard to enforce it in reality. There's also, and added to this really, is the issue that a lot of these AI tools were trained outside the UK, and there is actually a court case at the moment which is going to appeal later this year, which is hopefully going to address the issue of whether a work that's put on the market, whether an AI product that's put on the market in the UK but trained overseas infringes copyright in the UK. And we will see what happens there. So in the context of all that, really, what is the role of collective licensing? What can CLA do? What have we done? So collective licensing complements direct licensing or bespoke licensing. Bespoke licensing does help and works for larger rights holders and publishers in particular, but it isn't scalable or inclusive enough on its own. And collective licensing can provide a much broader coverage, allowing for legal certainty and efficient access for the user and fair remuneration for a much broader range of rights holders as well. And that's why we really see that RRO's role and CLA's role is to do as much as we can to develop collective licensing of AI uses. First of all, an RRO should be able to identify emerging market needs. We are market facing. We need to understand what our customers want to do and develop licenses that permit them to do it legally. We need to bring rights holders and users together to create that bridge between tech firms or other sorts of organizations that want to use AI tools and rights holders and communicate. We need to develop scalable permissions where we can start with a group of rights holders who are keen on participating in a collective license and then expand that to cover most, if not all, of a sector. And importantly, we need to demonstrate to all parties, including government, that licensing can work in practice rather than just in theory. So what we've been doing, we've actually developed 2 different market-facing solutions for generative AI licensing. So the first one on the left, workplace generative AI permissions. So this can be simply described as prompting rights. So making a copy to prompt an AI tool as part of your job or as part of teaching. We already sell blanket licenses to businesses, the public sector and the education sector in the UK, and we have done for many, many years. So what we have done, and starting with the business and public sector, education's coming next, is add new permissions to those licenses which allow prompting of generative AI tools. This is subject to certain conditions, and it is opt-in for each publisher, but it's in our licenses today. The other solution that I'm going to talk about is generative AI training, and we provide a solution to that for using published content for generative AI training, fine-tuning, and retrieval augmented generation. And I'll talk a bit more about that in a minute. So we did some research into the use of generative AI in the workplace, and this determined some quite useful information, and I think all these percentages will have gone up since we did it. So I won't just read all the numbers, but really employees in the businesses we surveyed are using generative AI at work. They're using it weekly, they expect it to increase, and very importantly, 82% of the people who said they were using AI at work use third-party content in prompts at least weekly. And on the right-hand side, you can see some percentages of what sort of content they were using, all of which we represent. So this was a real indicator that we needed to add these permissions to our licenses as a matter of course for all customers, because they were all doing it, and that's what we do. We license for a very broad range of uses: photocopying, scanning, digital reuse, and now prompting in the workplace. So we launched these permissions to the market in May 2025, just over a year ago. And like each month we renewed more customers. Each month we got more and more publishers participating. So we now have more than 750 publishers already participating, including quite a few big names of UK publishing. Over 1 million titles are now covered by the license for generative AI prompting use. This is in all our business and public sector licenses, or most of the public sector licenses. We're rolling out into education soon. There are a few key conditions which I won't run through, but one key condition is that the tools that are used must be those that don't train the underlying model with your inputs. So generally paid for versions, which is what businesses are using today. So with that in the market, we also turned our attention to generative AI training, which is much more of a controversial issue and subject to court cases and global discussion. And here we really wanted to develop a opt-in, scalable collective licensing solution. So we needed to make this wholly voluntary for rights holders, and that's why it's opt-in. It needed to cover all the kinds of uses that weren't covered by the workplace rights that we've already offered, all the way up to training a new large language model by a big tech firm outside the UK. We needed to cover all of those things, and we do in the license that we offer. We also knew that we needed to demonstrate to government that this was a real world product that meant that no changes to UK copyright policy are needed, even though they've said they have no intention to, currently have no intention to reform copyright law. It's the price of liberty is eternal vigilance or something like that. It's we have to keep an eye on what they're doing because they may change their mind and go, actually, tech firms have lobbied us even harder this month than we do want to change the law. So we need to develop a solution that works. And it has to work for customers too. So that's what we've been working on a lot over the last year. It's strongly supported by our authors and publishers. It's text only at the moment, but we do hope to include images soon. We've got more than 250 participating publishers at the moment. And really what we're doing at the moment is building up those publishers and talking to businesses, including quite a lot of organizations that are not tech firms, but they are just companies and public sector organizations that want to use AI tools in a way that isn't covered by our other licenses more systematically, and we want to provide them with that solution. So watch this space for that. I was also asked to finish up with some sort of advice really on how would we manage to get our rights holders to agree to license AI use collectively. And really it was all around building confidence. What we needed to do, looking back, was take baby steps, was to start off with the less controversial uses, such as prompting in the workplace on an ad hoc basis, and demonstrate that that is licensable and that the world wasn't going to collapse, and that really that there were really strong parallels with what we already license in our licenses today. Photocopying, for example, this is something that people do every day. You can't stop them doing. They do it as part of their job, and they probably don't think about copyright when they do it. We also really needed to develop the right safeguards and benefits to really demonstrate to rights holders that we were not going to be competing with their day-to-day work, but also to demonstrate to customers that there were real-world benefits in taking the license. And we generated £2.3 million extra in our first year of licensing workplace AI uses. So that's a really good example that we can use to demonstrate this. So I'm going to finish up with some, well, what lessons would I give? Start with the market need and user behavior. Separate out prompting from the other kinds of uses, TDM, training, because rights holders do see these differently, and if you go in with the most controversial thing, it's not likely to immediately work. Involve your rights holders early and consult them widely. Also, policy is always changing. Don't wait for there to be a perfect policy or for the government to do something to make it easier for you to license. Get the license out there. And also emphasize to all parties that collective licensing is there to complement direct licensing as part of a voluntary arrangement, and that you have a choice as a rights holder. That's what I would advise, and that's the end of my slides.
Thank you. Thank you, James. Your sharing highlight an important point for us. So even where policy development is still ongoing, the market cannot simply wait. So we now turn to Hong Kong, where the legal and policy discussion around AI, copyright, and TDM exception is still highly relevant. Our next speaker is Teresa, partner of intellectual property at Deacon's Law Firm in Hong Kong. Teresa will help us place the discussion in Hong Kong legal context. And this is particularly important as Hong Kong considers how best to respond to AI-related copyright issues. So, Teresa, may I invite you to share your views, please, Teresa.
Hi, good afternoon, everyone. So once again, thank you very much for HKTDC, HKRLS, as well as CETA today to invite me to conduct this sharing today. So I will be here today to talk about the legislative updates surrounding copyright and AI, and particularly in relation to the text and data mining proposal. So for today's quick outline, I'll first have a quick overview of the AI-related copyright laws and the position in Hong Kong, and then I'll dive into discuss Hong Kong's proposed TDM exception, which has yet to come into force, as well as the 5 restrictive conditions or the prerequisites that the government has stated that needs to be fulfilled proposed in order for the TDM exception to be relied on. So in Hong Kong has launched a public consultation to see whether in the wake and the proliferation of AI, whether there needs to be any changes to the copyright law. This consultation was launched in July 2024, and a consultation paper was then prepared and released in February 2025. So in relation to copyright, the main points that's derived from the consultation report is that for copyright protection, our current law is currently adequate in order to protect work that is generated through generative AI, because our Hong Kong copyright law does protect computer-generated works. In terms of infringement, it's found and agreed that the existing copyright provisions can tackle infringement because our law is technology neutral and broad enough and can cater into specific circumstances in relation to whether certain infringement is conducted by who when AI is involved. However, what has derived from the consultation paper is that there is found to be a need to introduce a text and data mining exception in Hong Kong. And this is to allow reasonable use of copyright works for the purpose of computational data analysis and processing, which includes AI training, without the need to obtain express copyright owners' authorization. And the rationale for this is to promote Hong Kong as an AI hub, as a tech hub for AI industry, and therefore such use would cover both commercial and non-commercial use when we're talking about use of copyright works for TDM. But in order to rely on this TDM exception, it is proposed that there should be several key restrictive conditions that needs to be fulfilled in order to balance the needs of the AI developers as well as the rights, the legitimate rights of the copyright owners. So generally, these conditions are: first, you need to have lawful access of the copyright work. Second, the work used cannot be infringing. Thirdly, there needs to be transparency. Thirdly, there must be no relevant licensing scheme, so there can be contract override. And fifthly, there can be opt-out options from the copyright owners. So what is noteworthy is that the TDM exceptions in Hong Kong is not yet in force. It's not legislated yet, but it's a proposal that's been put out there by the government. So as I understand, the next step is that the government will set out some non-binding guidelines to let the public have a guideline as to how this TDM exception is to be implemented. And then afterwards, we'll seek public sort of public voices and see how the legislative will be done. So in terms of the first two prerequisites, the lawful access and no infringing copies, they're very much, pretty much basically both sides of the same coin. So what does it mean by lawful access? We can somewhat look at the cases that are out there in overseas. So one example is a California US case in 2025 involving some book authors, Bart's, and Anthropic, which is the developer for Claude AI. So in that case, Claude AI is found to have amassed a library of books for AI training. So where these books came from, part of them were actually legitimately purchased hard copy books. And what they did was they stripped off the binding and then they scanned all of these hard copy books into the AI model in order for training purposes. But other part of these books are actually pirated versions that are downloaded online. So of course, the pirated versions that are downloaded online are counterfeits, they're infringing, and therefore cannot be used. There is no fair use in that regard. However, in terms of those hard copy books that they've purchased, that's originally, when they're published, they're not meant to be for AI training purposes, obviously, but those, the court found that there can be fair use in relation to those and lawful access for the TDM purposes. Another example of a court case is a Dutch case in 2024 in Amsterdam. So that relates to DPG Media, which is a German media company, and the defendant, it's Howard's Home, which is an online news aggregator. So in that case, Howard's Home scrapes information that is made public by DPG Media online, and Howard's Home would then use the scraped data to create news alerts for its customers. So in that case, Howard's Home relies on a TDM exception under Dutch law to say that they're able to do that and that the information that they've scraped online was lawfully accessed. So the court found that Howard's Home did make use of information that is freely made publicly available online by DPG, and DPG was not able to prove with sufficient evidence that any of the information that's been scraped was protected behind a paywall. Because if that had been the case, then if it was scraping behind a paywall and no payment was, there was no licensing, then in that case it might not have been lawful access. So from these two cases, it does seem that the term lawful access, therefore, does hinge on the owner's authorization to access. So in that case, it would be useful in the Hong Kong future legislation to define or give some guidance as to what constitutes lawful access, because it can be ambiguous. An example can be seen from EU. They do have a directive on copyright in the digital single market, which defines that lawful access should be understood as covering access to content based on open access policy or information that has been accessed through contractual arrangements such as licensing or subscription. And lawful access should also cover access to content that is freely available online. The next prerequisite is transparency. So basically, this refers to the AI platform's requirement to keep and disclose records of the source of the copyright works. And this is in order to enable any proof of lawful access. So in terms of the transparency requirement, much work needs to be done in order to educate the AI platforms of what needs to be disclosed and how these disclosures should be made. So for example, in the EU, the EU AI Act has actually provided a requirement that requires the AI users the AI developers to provide sufficiently detailed summary about the content that they have used for training the AI model, and this summary is actually to be provided in a template that is provided by the EU AI Act. So the template requires detailed summary of certain training data, identifications such as the name and the identifier of the data set, and also a link to the data set, the type and modality of the data, such as whether the data is in the form of text, images, audio, and so forth. The nature of the data content, such as whether it is copyright protected, whether it's personal data, whether it's open source, or whether it is hid behind a paywall and privately licensed, as well as how the data was derived. So whether the data was crawled and scraped from online sources, or whether the model actually uses any synthetic data. So all of these information about the data has to be disclosed. And in terms of how the disclosure has to be made, in the EU they require that the AI provider must provide this disclosure on its official website, but also on places of public distribution online. So for example, online platforms where the AI platform can be used and accessed. So this is an example of disclosure. Right now, the EU disclosure requirement, there's a grace period until August 2027. So then there may not be many examples of AI companies adopting that particular template at the moment. But then what we see on the screen right now is back in 2024, IBM has actually publicly disclosed the full list of data sets that they have used to train their LLM, Granite 3.0. So while the format out here doesn't specifically entirely correspond to the EU AI Act requirement, but then we can take a look at how the disclosure has been made. So this is an excerpt of example of technical data that has been disclosed. You can see that the names of the data set have been used. For example, things that are texts that are from Wikipedia, from Library of Congress, public domain books, so forth. And also the type of data, we can see that they're texts, and the nature of data, whether they're open access, they're from blog posts, public domain, and so forth. So the fourth prerequisite is that there must be no contractual override, no relevant licensing scheme. So under this restriction, a collective licensing scheme is crucial because that provides a means for the AI developers to use the copyright while having the copyright owners adequately compensated for their skill and labor. So in Hong Kong, I believe there needs to be an appropriate atmosphere and public discourse and knowledge and enough public awareness of the existence of voluntary and collective licensing scheme in order to ensure that while the copyright owners are fairly remunerated, but at the same time, if these information are legitimately derived, then the AI developers can use good quality information in their AI system in order for there to be good quality output as well. So in terms of the atmosphere, we can derive governmental support, examples of governmental support that we can see overseas. For example, in the EU, the European Parliament has earlier this year passed a resolution which requires there to be ensure that the collective licensing schemes are accessible to all stakeholders, including individual creators and SMEs for different types of work. So from this, we in Hong Kong, we may wish to have the government and various stakeholders join hands together to participate in the discourse to encourage the use of collective licensing schemes, especially teaching SMEs the importance of it, the existence of it, and setting up dedicated communication channels. For example, in Denmark, they have amended the copyright law to also introduce mediation mechanisms in order to assist with the negotiation of extended collective licenses. So in Hong Kong, for any of the collective licenses or licensing schemes, right now any disputes would be referred to the Copyright Tribunal, which is court-based and somewhat adversarial. So then I believe that we can explore more alternative dispute resolution forums, for example, like mediation, in order to help all the stakeholders to better negotiate these licenses. And from the legal aspect, I believe that the legal certainty in terms of the scope of the licensing scheme is important, particularly TDM licenses, because as we know, copyright is a bundle of rights, and whenever we have these licenses, there can be very specific as to what acts you can or cannot do, and even for TDM or AI training in itself, there can be a lot of different types of acts involved. There's reproducing, there can be indexing, integrating, and analyzing data, and so forth. So when we're contemplating these TDM licenses, it's very important for us to be clear and comprehensive as to what type of acts we are talking about, that is what can and cannot be done in this TDM licenses. And also, moreover, for copyright works, a lot of copyright works in Hong Kong, for example, publications, they do fall part of a licensing scheme, maybe like a copying scheme or a scanning scheme. Or if you're talking about music, there is public performance licensing scheme and so forth. So presumably, when we're talking about the TDM exception licensing scheme override, we're not talking about copyright works that are already in those type of licensing scheme, but specifically a TDM licensing scheme. So what constitutes a relevant licensing scheme should also be clearly defined in order to avoid ambiguity. So this is just an example of the US licensing scheme that we have. Just now, we have speakers talking about a lot of licensing schemes that are already existing in many other jurisdictions as well with regards to TDM. And then lastly, the prerequisite is an opt-out option. So TDM exception would not be available if the copyright owner has chosen to opt out. But what constitutes opt-out can actually be debatable. In the first case, there is a German case, Knesch and Lyon. So basically, this case concerns Lyon's use of Knesch's photograph as part of its AI training data set. So this photograph was licensed by Knesch to a stock photo website, and Lyon has downloaded the stock photo from that website in order to do its AI training. So what happened is that this stock photo website has contained a natural language opt-out in its terms and conditions, saying that you cannot use bots or crawlers to crawl my website in order to crawl these information to do AI training. And because Lyon has done that, and therefore they're being sued, and the court ruled that the court had to decide whether or not there was effective opt-out. And in that case, the court ruled that the natural language opting out did not meet the form that is required by the relevant TDM exception under German law. So that law states that for works accessible online, the opt-out must be in a machine-readable form, so which is text that is formatted so that a computer can easily read that opt-out without human help. But in that case, whether the natural language TNC opt-out was machine-readable was actually unclear. So in that case, they failed to prove that there was opting out. And secondly, the DPG media case that I earlier mentioned, the Dutch news aggregator case. In that case, the claimant, DPG Media, had also tried to argue that they've opted out from TDM because they did use programming language, for example, like robot.txt language in order to opt out certain bots. However, their opt-out only excluded certain AI bots, such as GPT bot or ChatGPT user, but did not exclude the bot that the defendant had used to crawl the website. And therefore, the court decided that the opt-out didn't work against Howard Home in that case, and there was no opting out. So from these cases, we can see that more legal clarity needs to be, there needs to be more legal clarity and explanation and clarity as to what constitutes an effective opt-out. So what can be done? Perhaps there needs to be uniform standards as to what constitutes machine readability by establishing a limited number of standardized machine readable formats, and also guidelines from authorities as to how to implement machine readable opt-out that can meaningfully exclude the broadest type of bots. So to conclude, clear takeaways is that in terms of transparency, there needs to be very clear transparency requirements as to what needs to be disclosed and how they should be disclosed by the AI developers. And relevant licensing schemes should be in place in order to create a favorable atmosphere. There should be the different stakeholders, such as government and the RO, should join hands in order to have more public discourse and more public awareness and education as to the existence of these schemes. And then in terms of opt-out, I believe that we do need more guidance as to how these should be implemented. So thank you.
Thank you. Thank you, Teresa. We have heard from Israel, Norway, the UK, and Hong Kong. So we now turn to markets that are at the early preparation stage. Beginning with the UAE, our next speaker is March, the director of the Emirates Reprographic Rights Management Association in the UAE. So March, may I invite you to share your experience, please?
Thank you, Sharon, for the introduction. Firstly, I would like to thank our host for having us here and for the opportunity to be speaking through this platform. ERA is a fairly new RRO established in 2022 with over 100 members and representing more than 5,000 works of these members. Also, ERA is the first CMO in the UAE and in the region. We're also a member of IFRO and the first to represent the Arabic language works. In 2025, ERA has sold its first 2 licenses to higher educational institutions. I'll now move to the presentation where we were asked to speak about challenges and opportunities in the age of AI. UAE has placed AI at the center of its national development agenda since appointing the world's first Minister of Artificial Intelligence in 2017 and launching the National Strategy for Artificial Intelligence in 2031 in 2018. The strategy aims to position the UAE as one of the world's leading AI nations by focusing on government transformation, AI innovation, talent development, trusted governance, and international leadership. Since 2018, AI has moved from policy to practice with wide deployment in government services and various national capability building initiatives. A series of national strategies, policy papers, ethical guidelines, and governance frameworks have since been issued to encourage the responsible development and adoption of AI. From a copyright and AI perspective, while some of these documents make passing reference to intellectual property rights, AI-specific copyright governance remains largely unexplored. At the same time, the UAE AI Charter expressly emphasizes compliance with international treaties and domestic laws in the development and the use of AI, providing an opportunity to integrate copyright into the evolving AI policy framework. As a representative organization of the rights holders of literary works, this presents an opportunity to ERA to enter the discourse that furthers UAE's vision while at the same time protecting the creators and their rights. As the UAE accelerates AI adoption, ERA's advocacy will support the national AI vision by promoting balanced copyright and licensing solutions. So ERA will prioritize engagement with government authorities to establish the policy and regulatory foundations for AI-related collective licensing before broader stakeholder engagement. Rather than focusing solely on collective licensing, ERA's advocacy adopts a holistic approach to AI copyright governance with the following strategic pillars: copyright and AI governance, lawful access and transparency, policy and licensing frameworks, future policy development, and guiding principles for ERA. The guiding principles for ERA are a balanced AI ecosystem where innovation and creativity reinforce and not compete with each other, support the UAE's ambition to grow its AI and creative economies, and promote collaborative licensing solutions that ensure AI innovation and creator remuneration can coexist. Speaking about building readiness for AI collective licensing, strengthening rights holders' awareness, so ERA plans to conduct baseline surveys to assess awareness of AI-related copyright issues, understand perceptions of AI training and AI-generated outputs, and share insights on global legal policy and collective licensing developments to inform future engagements. Through building institutional readiness, we engage authors and publishers through targeted workshops on AI, copyright, and collective licensing, increase awareness of international AI licensing developments and royalty distribution models, and work with right holders to expand licensing mandates for AI users as the UAE policy framework evolves. Developing future licensing frameworks. to develop a business licensing framework to address AI-related uses, to explore extending ERA's educational license to appropriate AI-related uses, and to design a well-balanced licensing model with appropriate legal and operational safeguards, to collaborate with government authorities and right holders on remuneration mechanisms. In international coordination, following progress on the domestic policy framework, engaging bilateral RRO partners to facilitate future cross-border AI licensing and remuneration, to extend AI licensing discussions internationally, and to facilitate inclusion of represented foreign right holders, and to support equitable cross-border remuneration. From a practical starting point for AI collective licensing, education, public administration, research, and media businesses each present compelling opportunities for AI-related collective licensing. The sequencing will evolve through collaboration with government authorities as the UAE's AI copyright framework develops. Interest from existing educational licenses in the UAE in AI prompting rights presents an opportunity to enhance ERA's educational license with AI-related permissions, which will strengthen the licensee's value propositions and promote responsible AI adoption in educational institutions. At the same time, public sector leadership to adopt AI collective licensing as part of responsible AI governance can demonstrate best practice and help establish expectations for lawful AI use across other sectors. With increasing AI adoption by media businesses, the sector too presents a promising opportunity for future licensing, with its scope evolving through awareness initiatives and government policy. So in conclusion, the UAE's adoptive AI policy framework presents an opportunity to integrate copyright into the next phase of AI governance. ERA looks forward to contribute to this journey through collaboration, practical licensing, solutions, and constructive policy dialogue. Our objective is simple: to ensure that innovation and creator remuneration evolve together and not at the expense of one another. Thank you.
Thank you. Thank you very much, Majd. So we now turn to Malaysia, another important market where preparation advocacy and institutional readiness are key priority. So over to you, please, Majd, CEO of the Malaysia Reprographic Rights Center, or Majd. Thank you.
Good evening, everyone. Thank you, Dr. Sharon. Thank you to TDC and also HKRRLs for the opportunity. It's a great honor to represent Malaysia and also Malaysia Reprographic Rights Center today at Hong Kong IP Roundtable. Around the world, government creators, we have heard just now from everyone that collective management organizations are facing the same questions. How do we encourage AI innovation while ensuring creators continue to be recognized, respected, and fairly remunerated? Malaysia believes the answer lies not only in choosing between AI and copyright, but in building trusted ecosystem where innovation and copyright can progress together. Today, I would like to share Malaysian current direction, government initiative, and how MARC is preparing for the future AI-related collective licensing. Is that okay? Right. Malaysia has adopted a whole of government approach towards artificial intelligence rather than treating AI solely as a technology issue. The government established the National AI Office under the Ministry of Digital to coordinate national AI policy and its implementation. Through this initiative, such as the AI Technology Action Plan, the National AI Governance Framework, and the National AI Code of Ethics. Malaysia aims to accelerate at AI adaptation while ensuring that AI remains responsible, transparent, and also trusted. Copyright forms an important component of this wider AI ecosystem. Protecting creativity and also encouraging innovation must go hand in hand. During the stakeholder consultation led by the Malaysian Copyright Office, or MyIPO, several consistent themes have emerged. First is legal certainty. Businesses, creators, and also AI developers all require clear and predictable rules. Second is innovation. All right. Second is the innovation. Malaysia wants AI to continue driving economic growth and technological advancement. Third is the creators' protection. Copyright remains essential to sustaining authors, publishers, and the wider creative industry. Fourth, you can see that on the investment confidence, ensuring Malaysia remains as an attractive destination for responsible AI development. Finally, Malaysia seeks a balanced framework that protects rights without unnecessarily restricting innovation. Sorry for this. One encouraging outcome from the consultation process during the Copyright Office is the remarkable consistency across stakeholder groups. Publishers, the creators, collective management organization, and media organization are not opposing to AI. Instead, they are asking for three fundamental principles. First is the consent, how copyright works are accessed and used. Second is the transparency, understanding what work are used for AI training. Third, fair remuneration, ensuring creators continue to benefit when their works contribute to the AI development. These principles provide an important foundation for future collective licensing discussion. Next. While government develops policies, collective management organization must prepare practical implementation. MARC's role here is not just to regulate AI. Our role is to prepare the licensing ecosystem while we are strengthening the rights holder mandates, increasing awareness among publishers and authors. We are also monitoring international developments like what our counterparts have shared through the support of IFRO and studying how collective licensing can evolve for the future AI-related uses. We believe preparation should begin today rather than just waiting until the market demands solution. Thanks. Looking ahead, implementation requires partnership from government, continual legal certainty, copyright reform, and AI governance will provide confidence for creators and also technology compliance alike. From MARC's point of view, we must continue strengthening mandates, engaging rights holder, building trusted licensing framework, and work closely with the AI developers and also users. We also believe international collaboration will be very critical because AI does not recognize national borders. Future licensing solution must therefore be across jurisdiction. Next. Allow me to conclude with these three reflections. First, AI is not replacing copyright. It is making copyright more relevant than ever. Second, collective licensing has an important opportunity to become part of the practical solution by enabling trusted, transparent, and scalable access to copyright works. Finally, Malaysia believes the future should not be about choosing between innovation and creator protection. It should be about building an AI ecosystem where government, technology companies, right holders, and collective management organizations work together. AI learns from humanity creativity. Human creativity must continue to be recognized, respected, and fairly rewarded. Thank you.
Thank you. Thank you. Thank you, Ahmed. Thank you to all our panelists for your thoughtful and insightful sharing. We now move on to the moderated follow-up discussion and the questions from the floor. Due to the time limitation, so I will need to skip my many questions and ask one question. And this is for Hager and James. Since your, models are relatively mature, so for Hagen and James, what lessons would you offer to the other regions seeking to implement AI-related licensing model and advocate similar arrangement with the government? May I have Hagen share your view first or experience?
Yeah. Thank you. Only some governments have so far explored the collective licensing as a way of enable lawful and sustainable AI-related uses of protected content. So one lesson is that the RROs can make the opportunity visible, I think. At the same time, RRO negotiates in two directions, at least, sometimes even 4 or 5. We negotiate with the user side, of course, but we also negotiate trust and confidence with our own right holders. And that part should not be underestimated. The mandate process matters. It takes time, but it creates legitimacy. And I think being very concrete about the proposed framework and transparent as far as you can be is of great importance. And of course, it's impossible to agree on all the issues before the actual remuneration is on the table. But I keep coming back to the process, to building relations through transparency, and that right holders need to get some glimpses into the negotiation room, I think, to understand the landscape and trust us. For an RRO, the real work is to translate broad political ambitions, innovation ambitions, and into concrete contractual safeguards, I think.
Thank you.
Yeah, I would agree with everything Hege has said. I would also like to add, I think for the creative sector and the RROs in a country, getting a license out there early, even if it's not the most perfect license, even if it doesn't cover everything you'd like to cover, is a great thing to do. We acted quickly. CCC in the US acted even faster to get it out there, because then you can talk to customers and rights holders and to policymakers about a concrete product which is available today. I would also, echo what Hege was saying about the need to include all different sorts of rights holders in your planning and communications. I know that we, through our author member, so we have 4 members, so the author organisation ALCS, they consulted widely, including with the National Union of Journalists, with screenwriters, as well as with writers of all kinds. And in publishing, we spoke to the journals publishing industry, the book publishing industry, the magazines, because you've kind of got to bring everybody along with you, and some sectors will be more reticent, and sometimes you may then need to make the license more granular and say, okay, well, only a certain sector of publishing is in. And I know in Australia they started with the newspapers because the newspapers were more comfortable, but now they're adding books and journals. So there's various ways that you can look at moving forward. But advice to or requests to governments would be to basically let licensing happen as it has done. Listen to requests for transparency, for example. But really, licensing bodies need support in this way to do what they've always done, which is license uses which are best licensed collectively.
Thank you, James. So any questions from the floor and from the audience to our panelists?
Thanks very much. So I've actually just submitted some questions through the QR code, but I thought maybe I just take the opportunity to ask questions over here. So one question I want to check with all panelists is how do you think, how important is Web3 and blockchain as part of the infrastructure? Because there has been some discussions of how creators can put up the work on blockchain so that we can have some sort of token to protect our rights. But obviously, there's a lot of infrastructure work involved in this particular direction. So I'd like to check with the panelists of regarding your observations for these kind of initiatives in different countries. And second question for all the panelists would be, so are there any cases, so when we talk about rights, of course, there's like text-based rights. And then we could talk about cases where we translate a particular work into other languages. But my partner and I, we work in the science fiction publishing industry. So sometimes the kind of work will also be adapted to films or like micro movies, where a lot of AI generated content is involved right now. So in terms of legislation, is the focus mainly on the text-based at this point in time, or do you already see some kind of initiatives for the protection of other kind of media, especially for IP adaptation? Right, so these are my questions for all panelists, and I still have some other questions for individual speakers.
These two first.
Okay, sure. Yeah, thank you very much.
Thank you for your questions. So it's about blockchain or extended rights. So may I invite lovely Sarah?
Just lovely. I'm not sure if I'm the best person to answer this question, but Teresa looks like she wants to answer. I would just observe that one of the biggest problems with AI licensing is the question of traceability and distribution. So from my perspective, I can see a role for blockchain technology in helping CMOs and RROs find a way of traceability, because let's face it, the AI companies, I don't think they even know what they've trained on at this point. They kind of just trained with whatever they could get their hands on. So the traceability is a real issue. And on the CMO side, I think blockchain could help with the distribution side. That's just, I don't think anyone is working effectively with it yet. I know there's an interesting project in Switzerland that our member there, ProLiteris, is working on, but it's really early days. But certainly I can see a use case for it. I just don't see how I don't see it in the market yet.
Yeah, I totally agree. I think in terms of, the traceability part, and I understand that there have been some discussions in the EU, for example, about allowing the copyright owners to watermark their copyright work, and then the AI developers should be required not to take away that watermark. So I don't know technologically whether it can work or how exactly it works, but then I think that is something that can be explored to see whether blockchain or Web3 can come to play in terms of the watermarking. And on your second question as to the legislation, whether it's text-based, I know today's discussion focused a lot on text-based, but actually as far as Hong Kong law is concerned, it's actually technology neutral. So whenever we're talking about using copyright owners' work in AI training, we're talking about all modalities like text, images, videos, micro the blogs or like the micro videos. So those all types of content would be protected as copyright work. And then whenever you use those like facial images in order to feed into the AI platform in order to create some AI generated videos, like those would also be included, contemplated as the acts that we are thinking the TDM exception should apply or not as well.
If I could just contribute also from an international perspective, that's also the case internationally. Hong Kong the law is applied exactly as Teresa's explained, but certainly internationally when we're talking about AI, we're talking about AI as it relates to copyright, we're talking about all creative sectors. So there's already major legal cases in relation to music, visual artists, all that. Every creative sector is basically impacted by AI development. So when we all come from RRO, so we're all very focused on the text and image sector, but we do a lot of collaboration with other creative sectors as well. So it's a global problem across all creative sectors.
And if I could just add sort of my perspective on the blockchain question, we're not looking at it at all for our licensing. And my personal sort of rather cynical view is that this is the kind of thing that tech companies or pro-tech people would throw in as a red herring to go, oh, there's a problem. The problem is that they're not complying with copyright law. It doesn't have to be fixed with technology. It can be fixed with complying with the law and getting a license. So I would say let's get the licenses in place. And then if there is a need for some very expensive technology to track everything, then maybe let's do it. But we've done this for more than 40 years without having it. We kind of fulfilled some of the roles of that kind of technology ourselves as RROs to be a trusted intermediary that isn't that is non-profit. So we can provide some of the solutions ourselves. And that's my personal view.
Can I just make an observation on that as well? That the whole technology company is saying, oh, look, there's a problem and we don't know how to fix it. That's my view also of the TDM exception. When you think about it, this whole machine readable requirement on the TDM exception, it's mind-boggling that these tech companies can develop systems which can basically, we've all seen what AI can do, and somehow when it comes to copyright, they need a very specific form of opt-out in order to recognize it. It does seem to me like a little bit of a red herring or a little bit of a, look, there's a problem over here, don't look at the problem over here situation, because it's very odd that such refined, well-resourced organisations somehow can't manage a natural language opt-out. It's just, I think it's just inconvenient for them, frankly, but yes, there you go.
Yeah, to be machine readable will be, too costly and put all the cost to the right holders, maybe, yeah. You want to add on? Okay. So okay, one more question. Oh, okay. The lady first.
Hi, Sharon. I'm Victoria from HKUST. I put it in the QR code too. So there's been a lot of discussion of collective licensing, but I was also wondering, do ROs see a role to help individuals in a sort of transactional license type of way that if, for example, a student entrepreneur came to me and said, I really would like to be able to ingest these 5 economics textbooks for my model to do X, Y, Z for profit. And it's usually very hard for young, inexperienced people to even get a response from a publisher. And so do ROs see that this might also possibly be a role that they could have? Thank you.
I can answer that in a couple of ways. One is that, yes, certainly we would love to help with that kind of issue. In the UK, there is a non-commercial text and data mining exception, so some of these things may well be doable. Well, if they want to make money off it, then they can definitely come to us because our license, the training solution is flexible and it would allow that kind of use. But I would also add that our friends at CCC in the US do offer, or are beginning to offer, transactional AI use permissions where you can just select exactly what you want to do and get a cost. So I don't know any more about it, but it is being developed by ROs. So that's a great question. Thank you.
Yes, and in Norway, we will also would like to help with this sort of licensing, but we experience that the publisher themselves don't want us to have the mandate, because then we're into their field of their market, so to speak. So, and then we back off as an RRO.
In Hong Kong, we are quite fortunate. We have a close collaboration with Hong Kong University of Science and Technology. So hello, Victoria. And any add-on? So Ponch, Mr. Punt, question?
Thank you once again for the wonderful and insightful sharing. Two simple questions. The first one is, the local publisher here in Hong Kong, I think most of them choose to, during this confusing and uncertainty time, they choose to sort of like using the opt-out option to protect the copyrights. So my first question is, how would you suggest from this perspective to balance between fostering technology development and protection of copyrights in general? Because if we look at, if most of the publishers choosing this opt-out, then really, I mean, I don't think we will have a very successful usage of AI here. Then the second question is, other than technology and law, if we look at from an education perspective in other countries, can you share with us any best practice or very successful case as to how we educate the user, the end user, so we don't necessarily have to looking at like law and technology only? Thank you.
To your first question, Ponch, I think might sound like a silly example, but I just keep thinking it's like if you live in a really dangerous neighborhood, right? And there are criminals everywhere, burglars everywhere. You got to lock your doors, right? Your first instinct is going to be, I'm going to lock my doors. I'm going to shut everything down. I don't want those criminals in my house. So to be clear, I am very pro AI. I use Claude all the time. It's very, very useful. It's an amazing tool. But the history with tech companies so far is that they've just come in and they've just taken everything and then they've left and said, oh, look, there was a problem and we don't know how to fix it, but look what we've done over here, right? So that's basically, so I think maybe the instinct for the publishers is correct in the sense that they don't have any confidence at this point that they will be fairly remunerated for their decades and decades, sometimes centuries of investment in their companies and the works that they've created. I think what we need to move towards, though, is a more collaborative relationship with AI companies, and also for governments to step in and make a clearer framework. And I think this is what I talked about in my presentation. There is kind of like a dual responsibility between governments to make sure that there is actually space for effective licensing to take place. And then once that is in place, there's a role for CMOs and also rights holders to make sure that they are reasonable in their licensing terms. So I think the instinct for, it's correct, your concern is correct. If we shut down and refuse to have good quality materials being ingested in AI companies, in AI tools, we will not have good AI tools. They really do need this content. They really do. They can say all they want, oh, we've got everything we need from the free internet. They don't. They need the newest research. They need the newest literary voices. They need quality content. So if we shut it all down and say no, then we sort of run the risk of shooting ourselves in the foot. But at the same time, there needs to be that trust in the environment, and there needs to be a regulatory process in place, I think, where people can feel confident in licensing their material. That's what I think.
Yeah, I totally agree with what Sarah said. It's really a good point. And I also would like to add that you should probably try to swap instincts with knowledge. And I think fear and skepticism is a very strong driver here. And my experience is that when you're being concrete and when there is fair remuneration on the table, all the big publishing houses in Norway have joined in because they want to be a part of this new economy. It's not very big yet, but they want. They're all in, and all of the 200 Norwegian newspapers as well, except from one, have just one have opted out so far. There may be more, and I think, and what James said, just to start small with baby steps and set an example that there's and you have to be patient. That's it's hard because it's moving so fast. Yeah.
I'm not sure any of us would have answers to the second question that you asked, but I think going back to the first one, something that we've realised and we really want to get our rights holders to understand, so they're not just saying no to everything, is that there is not just the big tech companies as the market, and if they don't pay, then you get nothing. But actually, there's a whole load of other commercial opportunities where there's actually probably a lot more money to be made in the next few years from organizations that are, maybe using Claude as like the basis of what they're doing, but they want to build a specific pharmaceutical industry research tool for their researchers, and they're willing to pay for the right to train on high-value science content, things like that. They're the opportunities where actually really rights holders and governments and ROs should be able to get behind that. That's a great use of AI. So, I would leave it on that positive note.
I don't want to leave your second question hanging. So I don't think any of us have a solution in terms of the education piece, but I just wanted to make two observations. Firstly, I think the Norwegian model of excluding textbooks, recent textbooks, is really important, right? Because a lot of governments issue national curriculum, and it's really, really important that that material stays, how would you say, as high quality as possible and is not ingested into AI systems. On the education piece, I would just say that, in Australia, I think they've made an effort to make sure that there's AI education from a very young level, like kindergarten to year 1. They're already learning about AI. I think AI is here. It's already here. It's been here for a few years. It's not going anywhere. We can't be frightened of it. We can't sort of shove our heads in the sand and pretend it's not happening. We all need to learn to use it. And I think education publishers are probably going to need to adapt quite quickly to make sure that their publications are AI suitable. Someone's got a question over there now. But yes, I would just say that it's here. We need to use it. We need to be very, very adept with it. Otherwise, we will get left behind. That's all I would say.
We can talk after the forum. So thank you very much for all our distinguished panelists for your excellent contributions. On behalf of TDC, HKRRS, I would like to express my sincere thanks to Sarah, Hagen, James, Teresa, March, and Ahmed today, and for sharing your valuable insights. So I would also like to thank our audience for your participation and questions. So thank you once again, and I wish you all a very productive and enjoyable Hong Kong Book Fair. Thank you.
Here comes the end of the discussion session. Once again, on behalf of the Hong Kong Trade Development Council, I would like to thank our guest speakers and all of you for joining us today. 今天的圆桌会议圆满结束，我仅代表香港贸易发展局再一次感谢各位演讲嘉宾和在座各位的支持。Thank you very much and wish everyone a fruitful visit at our HKTDC Hong Kong Book Fair. 祝大家在香港书展满载而归，谢谢。